My name is Ransford, and welcome to today's edition of Retirement in 60 Seconds. Today we will be talking about retirement. What is retirement? Retirement is a time in life when the main source of income changes from active income to passive income, that is private investments, pensions, etc. It can be forced or voluntary withdrawal from the job market. In Ghana, the normal retirement age is 60 years, but one can also choose to go on voluntary retirement at 55 years. Till we come your way again in our next edition, remember to plan well. Enterprise Trustees, your advantage.
Enterprise.
Life is in stages, and how well we prepare for each stage determines how well we will live the next stage. Our retirement is one of the most important stages in life, and we must prepare for it. While we are working, it is essential to make a personal commitment to our future outside the mandatory pension provisions by the government to ensure that we live a comfortable life at retirement. I'd like to introduce the Enterprise Personal Pension Plan to you. It's an individual retirement plan that helps you boost your retirement income. No matter what you do, secure your future today with the Enterprise Personal Pension Plan. As Harry Fosdick said, don't simply retire from something, have something to retire to. Dial *714*333# or download the Enterprise Advantage app on Play Store or App Store to sign up now.
Enterprise, your advantage.
Hi there, my name is Doreen, and welcome to today's edition of Retirement in 60 Seconds. Today, we'll be talking about the importance of updating your beneficiary information on your pension account. As a member of a pension scheme, you are required to nominate beneficiaries for your account. This will ensure that in the unfortunate event that you are no more, your surviving beneficiaries, such as children, spouse, or other family members, will have a seamless and smooth experience accessing your accrued benefits in your pension account. Secure the future of your loved ones. To update your beneficiary details, go to our member online portal, The Stable. Log in with your credentials, select personal information, scroll down to beneficiary details, and select Add Beneficiary. Make sure your beneficiary information is up to 100%. Take action now and nominate your surviving beneficiaries today. Till we come your way again, remember to plan well, retire well. Enterprise, your advantage.
Enterprise, your advantage.
A very good morning. You are welcome to today's webinar series that is powered by Enterprise Trustees, Your Advantage. This is the third edition, and I'm super excited to come your way again. My name is Cassandra, and I will be your moderator. Today, the topic is centered around succession planning, wills, beneficiary nomination, and management. The process of having a succession plan is ensuring that your assets, your roles and responsibilities are designated before your demise. But the truth of the matter is, most of us do not do this. Now, despite the fact that having a will is very, very important, it will surprise you that people who die without a will, when we look at the statistics in the world, is 60% of people. In Africa, is 70% of people. And in Ghana, 80% of people die without a will. Now, ask the question, what is the use of working hard, planning financially for ourselves and for our loved ones if we do not leave the simple documentation to see who manages and what goes to who when we die? Today, the topic is very, very important. So do share. We are live on Facebook, Enterprise Trustees. We are also live on YouTube, so share as many times as possible so that someone can also learn from the webinar today. My speakers, or my guest today, my first guest is Cynthia Apiedu. She is the Senior Legal and Governance Manager at Enterprise Group. And my second guest is Nana Asante Amwakun, who is the Head Customer Experience at Enterprise Trustees. And they are going to be helping us to understand why it is important for us to plan, to have a succession plan. You're welcome.
Thank you.
I was teasing them earlier and saying that I see the purple everywhere. Did you get the memo? Was there a memo that I didn't get?
Well, no, it was just the
Coincidence.
cover is for the enterprise
Enterprise
trustees.
trustees.
So we just showing solidarity. For
All
them, so.
right, I get it, it's the branding.
Yes.
But once more, welcome you to the webinar series.
Thank
you.
Lovely to have you. Cynthia, let me start with you.
Sure.
What is the importance of having a will? I am sure that before we even go to why, someone should have a will, let's just assume that some of us do not really know what a will is. So if we talk about having a succession plan, and in this case, a will, what are we talking about?
Okay, so a will is essentially a document which expresses your intention or what should happen with your property, your self-acquired property in the event of your death. And it also gives you the opportunity to state how your affairs should be managed. So it's not really just about your disposal of your property, but you can also use the will to leave certain instructions on things that you want to be done or how your affairs should be managed when you pass. The will it's a document that takes effect only after you die. So you can do the will today, it doesn't come into effect. It only it gets into effect when you die. So it gives you the opportunity to change it, to alter it as maybe life events change for you. But the thing we should all remember is it doesn't take effect until you're dead.
Until you're dead.
Yes.
Why is it important for us to have a documentation stating, how we want our assets to be managed?
I think you put this very succinctly in your introduction, that you work so hard, right? Every day you get up, you drive through traffic, you go and sit behind a desk. There's a reason why you're doing all that, right? You're trying to. There are certain people that are important in your life that you're seeking to achieve something for, to take care of them and ensure their well-being. So it is important to have a will for you to have absolute control on what happens to your property that you have worked so hard to acquire after you die. So essentially, it's the power is in your hands. The will gives you the power in your hands to determine what happens to your property when you die. And also, it just gives you the opportunity to have affairs managed the way you would have wanted
to manage,
rather than leave it to certain persons that you probably wouldn't have chosen. To do that for you. So it's necessary to have a will just for those reasons.
Personally, I up until maybe quite recently, I thought a will was only done when you are 80, 90. That's when we probably hear of will and stuff like that. At what point in our lives must we write a will?
It would be perfect to wait till 90 if you know that you are dying at 90. Yes, but that's the thing. The only certainty in life as humans is death. And the unfortunate thing is you don't know when you're dying. I mean, people die young, people die old. I'm sure one of the lucky ones to die old, that's up to you. But we advise that you prepare a will as soon as you start acquiring property. Anybody, per the law, if you are 18 and above, you can make a will. The requirements 18 and above, and you should be of sound mind because you need that mental capacity to be able to make a will. So what we advise, you're 18 and you have property. Some people come into property even by the time they're 18 because they would have inherited property that they can't. It doesn't vest until they are of mature age. So once you're 18 and you have a property or you start acquiring property, it's advisable to leave a will. As I mentioned, it doesn't matter when you make the will. You can always alter it in intervals. We advise that maybe every 5 years, or when life events change, maybe you get married, then you want to bring your wife into the ambit of the will. You start having children, you want to bring them into the ambit of the will. Or if something else happens in your life, unfortunately, maybe a divorce or one of the beneficiaries under your will passes, something like that. So we advise that intermittently you update that will.
But from 18 years, legally,
you should
be considering making a will. Now, let me come to you. In planning or in having a succession plan, who is a beneficiary?
So basically, when we talk about beneficiary, it could be a person or an entity that you choose to receive your funds when you die. Like Cynthia rightly said, the certainty in life is that we all die one day.
Yes.
And unfortunately, we don't know when we will die. So it's important that at every point in time, you have beneficiaries on your account. Let me be quick to add that when it comes to your pension funds, when it comes to the tier 1, tier 2, tier 3, or personal pensions, when it comes to some of your insurance, life insurance policies, and even your financial investments, the will might not govern it or will not govern it when it comes to pensions. So nominating a beneficiary is a legal process when it comes to pensions, of you saying that when I die, when I'm no longer around, my funds should go to A, should go to B. So it's a legal process that we use to choose who should receive what when we die. So basically, the beneficiary are the people who receive, or the entities who receive
when you die.
When you die.
Is it the same as next of kin? When we buy financial products, sometimes we get next of kin beneficiary. Is it the same, or are there the next of kin doesn't get the...
So I think Cynthia will add a little to it. But let me be... One thing I know is that for when it comes to enterprise trustees and the trustees, some of the trustees I know in the market, usually on the forms or when you go to the portal to update the details, what you see is beneficiaries and not next of kin. So usually the next of kin could be someone who is close to you, who is a relative that we can fall on to take some decisions on your behalf when you are in a position where you cannot make those decisions. And it does not necessarily mean that your contributions or your funds or assets will go to them when it comes to your pensions. So usually you see that we indicate beneficiaries and not next of kin. But I'm sure that legally Cynthia can throw more light on it.
Yes, you're quite right. The next of kin is just a close family relation who essentially the company would contact to sort of manage the affairs.
Have you had situations where people confuse the two?
It happens all the time.
It
happens all the time. There's a lot of confusion between who an administrator is, executor, beneficiary, next of kin. It comes up quite often. But beneficiary, just by the word, and just keep in mind benefits. So who is getting the benefits when you pass? So that goes to the beneficiary, who you must name in the trust document. He's very right when he says the trust scheme falls out of a will. So if you pick the beneficiaries under their process, under your pension scheme, you can't devise that property or the benefits under your pension scheme under your will. We will go to the document they have that names the beneficiaries and give that entitlement to that person. So it's very critical that you ensure that you make that process of naming a beneficiary, under your pension
I believe by the end of this morning, we should all be on the same page to actually understand so that we don't, make that mistake of writing. Perhaps you intend to make someone a beneficiary, but you've only named them as a next of kin. And perhaps you want someone to just be a next of kin and you have gone to name them as a beneficiary. Hopefully we'll be able to understand. But Cynthia, let me come back to you. What are some of the consequences? Because I think that is what will now begin to highlight the importance of having a succession plan. What are some of the consequences of not having a will?
Okay, so per the Ghana law, if you pass without a will, you are deemed to have died interstate, what we call interstate. And then the interstate succession law will kick in. What that law does is to name specific persons and specific proportions of your estates that should go to them. So it's usually maybe your spouse, your children, and maybe your parents if they were dependent on you at the time of your death. And it has strict percentages of demarcation of those persons. And it also has a process where somebody will be picked as administrator of your estate. Okay, so once you pass without a will, all those issues are out of your control. You don't have any control on who becomes the administrator of your estate. That sort of sometimes leads to a lot of family issues because the family would now try and decide who is the right person to be your personal representative in the event of your death. And then also, sometimes, you would have gone through life, made certain acquaintances and certain important relationships in your life. that you would have wanted to appreciate, but you didn't leave a will. Those people don't fall outside the ambit. They fall outside the ambit of the intestate succession law because it's strictly to certain persons when you die. So you may have gone through life. Somebody helped you out. You would have wanted to leave something to them in your will, or the thing that comes up of in stepchildren. You would have married somebody and acquired stepchildren. The law doesn't cater for stepchildren. So sometimes it can leave chaos behind you, which you would have had the opportunity to sort out if you had left a will. So the consequences can be that. Sometimes it leads to litigation all the time. We see people go to court, especially where the estate is large, where there are a lot of assets, a lot of property, and it becomes greed sets in, the family fights. It can be in court for years, you know, and you probably wouldn't have wanted that. So the consequences can be depressing.
Can be dire. But let's be honest, does it not psychologically dawn on us when we're about to write the will that, does it mean I'm going to die?
Well, sometimes I get that a lot.
Yes.
I get that's a lot from people. You'll be surprised about how very educated people still even have that reservation that, okay, if I make a will, I'm preparing to die. Or if somebody finds out that I've made a will, they'll kill me. I've heard that quite often, that if they know I've made a will, they're thinking that they are inheriting.
And they know exactly what they're getting.
You're not supposed to disclose the contents of the will.
Not even to your spouse?
Not even to your spouse. You can, but you're not supposed to.
Okay.
So it's... a lot of people have that reservation that, okay, I could get killed because I left a will.
Yeah.
But think of the other side of it.
It's true. The consequences.
The consequences of it. I think it far
outweighs
the benefits
absolutely
of leaving a will. So,
absolutely. Now, let me come to you because you are, you deal more with the financial product. Like I said, we work hard for this money, and that's to take care of us, our pension when we retire, and also our loved ones when we are no longer there. Why is it important to nominate a beneficiary for your pensions account?
So,
and other financial accounts for that matter.
I think that in addition to what Cynthia said, to prevent the chaos and the misunderstanding when you're no more, I think it also prevents the stress that your family will go through to access the funds. So today, if you've not nominated beneficiaries for either of your pension accounts or either of your financial products, what it means is that when you die, your family would need to get the letter of administration for us to, based on that, distribute the funds to them. And unlike our process, when you nominate beneficiaries, within probably 5 to 10 working days, we could process and pay out these funds to them. But you have to go through the process of getting the letter of administration. I think it doesn't take less than 21 working days. Yes, for them to get that. So it's prolonged the benefit payments process, as well as the stress they will go through. They would have to, I'm sure that it's not just that straightforward, as Cynthia said.
Even to get the administrator, as she said.
Yes, to get an administrator. Sometimes they will call, probably the administrator should be a opinion or someone. And if there are conflicts in the family, getting all these people to come together to get this letter of administration, sometimes the family will go through a whole lot of stress. And I think, as you rightly said, we've worked hard and we've earned these funds. We would have wished that we all live to enjoy the fruit of our labor. Absolutely. But we don't know when. We don't know where we go. So as part of the management process, it's important that we nominate. And it also gives us the opportunity to decide who gets what. Yes. For me, I think that is very important. Because today, when you're not there, we decide for you. The laws of the land will decide that your spouse will get this, your children will get this. Yes. I know that in some jurisdictions, they give priority to the spouse and the children. And I think for the pensions area too, we do same for the children, especially if you've not nominated your children as part of your beneficiaries, and they are able to raise this issue and file in court. They are able to get or included in your beneficiaries. But it's important that to prevent all the stress that family will go through, to also help you decide who gets what, and to leave your family at peace. It's very important.
I was about to ask that what happens if a person doesn't nominate a beneficiary, but I think you have touched on a bit of that. You will still have to go through the court process, which is quite tedious. But let's be honest, I mean, in our culture, in our side of the world where, yes, you're legally married to one woman, but then you're traditionally married to another, it becomes really chaotic, yes, because perhaps you have other wives, but I believe the law only recognizes the one. Cynthia?
Well, it depends on the type of marriage you embarked on. You know, Ghana, we have 3 types of marriages. Okay. You have the ordinance marriage, which entitles you to only one wife. Yeah. Then we have the customary marriage, where that's a polygamous marriage, so you can have as many wives as you want. And then the Islamic marriage, which allows you to have 4 wives. Okay. So it really depends on the type of marriage. But the thing about Ghana customary law is, so long as the children are yours, we don't have the concept of illegitimate children. So even if you're married under the ordinance and you have kids outside the marriage, they will still be recognized as your children, so long as they are biological. Okay. So the concept, it's even one of the reasons why you should leave a will, because very often we see the illegitimate children cut out of the administration process if you die without a will. But if you leave a will, you can't cater for those illegitimate children under the will. Yeah, so it just goes to show that, I mean, you should make one, especially if your marriage affairs were not very tidy.
We've had too many of funerals where while he's laying there, we have 20 women with kids coming to say no.
Yes. So I mean, if you had that opportunity to leave a will, you would have acknowledged them, and also really, even if you leave a will and they are your children, but you didn't cater for them in your will, the Wills Act gives the court the opportunity to order that your estates be used to cater for your children under 18. Okay. So if you have minor children and you died, even if you left a will but you cut them out of the will, the law can still bring them back into the will. Really? Yes, if they are minor children. So, I mean, the Wills Act tries to accommodate.
Okay, let me go to Nana and then I'll come back to you. Nana, what changes in personal circumstances might prompt someone to update their beneficiary?
Okay, so I think Cynthia touched a bit on it in her earlier submissions. So the major events in life, I'll put it that way, when you marry and you can decide to bring your spouse under the umbrella of your beneficiaries. When God blesses you with a child or children, you can also decide to do that. Unfortunately, when you go through divorce or you remarry, you would also want to visit the beneficiaries to see those you've nominated and adjust accordingly. I have a friend who usually shares this story with me that before he got married, the mom and the sister were his beneficiaries. Okay. And he usually, once in a while, gets this conflict, friction with the sister. And as soon as that happens, you call me, Nana.
Sister, change it.
He wants to change it. I can't change it for him, so he would do the changes. Then he will either take the sister off or give her like 10%. You get because they don't have they are not on good terms. But when they come back,
you call again.
Again. I said, then go to the portal and do the needful. So you see, it just gives us the idea that you are able to make changes at any time. Any point in time, you can make the changes. So you don't have to wait till you marry or there's any major event in your life. At every point in time, as Cynthia mentioned earlier, probably someone has done something good to you, you want to acknowledge the person. You want to add that person to your beneficiaries. Not that you are just giving the whole thing to the person. You just want to add that person. Even if it's 5%, 10%, you just want to add that person. You can do that. So at every point in time, aside the major events, you can as well visit our website, our members portal, the stable, to update the beneficiaries.
This is quite a tricky question, but I would still throw it to you. Do you influence sometimes the percentage? Do you sometimes advise?
No.
You don't?
We don't. We can't tell. What we advise is that whether you nominate one person or several people, several parties, the allocation should be equal to 100%.
All right.
The allocation should be equal to 100%. So regardless of the number of people you have as beneficiaries, you just have to ensure that it's up to 100%. For who gets what, let your wife get or let your spouse get 20%.
You don't try to influence the person.
We don't do that.
All.
We don't do that. You are not allowed to do that.
Before I went to Nana, you were talking about the minors. I think something has clicked. I want you to go back there. So a person writes a will, has a son who is under 18 years, so still considered a minor, and decides that this son didn't do what I want him to do. I've cut him off my will, and he dies. And that is his will. This is my intention. this boy, don't give him anything because he didn't do what I wanted him to do. You said something about the law providing for the minor. Please explain that again for us.
So, I mean, children are protected class of people. So if the child is under 18, a minor, the will, and you cut them out of your will, there's a provision in the Wills Act that says that they can apply to the court for you to for them to be catered for from your estate. So even if you cut them out of your will, there's a possibility that it could be brought back in. It doesn't necessarily apply to children, your biological children above 18. But those who are minors are usually protected persons. And even the protected persons under the Act are your children, minor children, and your parents if they were dependent on you at the time of your death. So they can be brought back within the ambit of your estate, even if you cut them out of your will.
All right.
Yes.
Even though Nana said something about it, I want you to also touch on it. In terms of the percentage, have there been times where, from where you sit, you try to advise? Not to, I mean, it's a person's prerogative, but you try to say, listen, from where I sit, I see this becoming, a bit chaotic, especially when the percentage is this way. Do you not want to make it that way to cater for the kids?
Well, we do get that question often from people who are uncertain about how to demarcate the estate.
Yes.
So we can provide some sort of guidance. Maybe from precedents or what we've seen people do. But ultimately, the decision is yours.
Yeah.
We can guide you that, okay, especially where the children are, you have minor kids, we would want that you put a bigger chunk of it. Because when you die, there would be education, making sure, taking care of these children. So we usually advise that you create sort of a trust, and then a bulk of the estate should be put in that trust. For the people who are older, I mean, they are already on their way, they can take care of themselves. So if you have minor kids, yes, we can advise that maybe you put a chunk of your estate into a trust to cater for these kids. But in terms of actual percentage numbers, I will hardly ever go to that extreme. Yeah. Okay. So we can guide you on what the ultimate decision should be. But as lawyers, we work based on our clients' instructions.
Absolutely.
So ultimately, what you decide is what will go into the will.
Now that you mentioned trust, can you educate us a little bit on the difference? What is a trust? When does a trust come in? Okay,
so a trust is just it's also sort of a document. You can actually create a trust within your will. But it's where you put some assets, the person making the trust, you put some assets of yours in sort of like a pool, some sort of pool. You nominate a trustee to take care of that pool, and it's for the benefit of somebody else. So the trustee is not the beneficiary, you have a beneficiary of it. So an example would be, I nominate Cassandra as the trustee of my will, that my house and airports, my car, this blah, 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 my money in these accounts should put in a trust for the benefits of my child when he turns 18 or when he turns 21. Or something of that sort. So a trust creates a pool for the beneficiary to come into it when at a certain time. So you state when the trust would mature, basically. So that's how we create trust. You can create it within the ambit of a will. It's especially done where you have minor children. It also gives you opportunity to appoint maybe a guardian for the children when you die. It doesn't necessarily have to be the same as the trustee. So the executors of the will can be the trustee, and then you can direct that this person be my children's guardian. They should take care of their education, but then the trust should go to the kid when they are 21, 25. It just depends on what you decide.
While we're still with you, can you, into a more detailed, explanation, help us to understand how writing a will can help us avoid disputes and, problems in the family?
Okay. So the issues we usually see about when you leave when you die without a will, relation to who inherits what. Okay, even sometimes among the kids, right? There will be issues where the one kid will say, well, my father told me that I get this property when he passes. But that could not be, it's possible it wasn't true.
It wasn't true.
Or even if it was true, if you're making a gift to somebody, it must be published. Like, you know, everybody must be there and it must be here, must be here. So in situations like that, other kids will dispute it. And then it becomes a fight. Okay, I'm supposed to get this. The other kids are saying the father never told us that.
Yes.
So you start having problems right there. And then outside the nuclear family, the extended family also comes in, because once you die without a will, per the intestate succession law, there's a portion of your estate that should go to your extended family.
Extended family.
Yes.
Okay.
So once the other parties start coming into the mix, and the fights start happening about what they are entitled to, because you know when they talk about percentages about the estate, you can't go and divide the house. If there's a house, you can't go and divide into 1/16.
Yes.
So what happens is that you would have to sell that asset.
Okay.
And then when you sell the asset, the money you get is what is divided into that. So that it creates a lot of problems and confusion. You know, so if it comes into intestate succession. So we usually want you to avoid that. It's a very detailed law, which if ideally families will just go according to what the law says, we won't have any issues, you know. But it leaves the family to decide who the administrators should be.
Yes.
And there sometimes the administrators don't do their job, which is the critical thing.
Okay.
You know, people think that if I'm appointed as an administrator of an estate, it means the property is mine. It's a common confusion.
That's a common confusion.
It's a common confusion that they think the property is mine. I can decide who I give what to.
Okay.
But once you're an administrator of the estate, you're supposed to go and take the law. It's a job. It's actually work. So you go and take the law. See what the law says you should do as an administrator, because if you don't do your work, they can actually be sued for not doing your work right. See, but there's so much confusion. People don't even understand the administration process. So when somebody is appointed as an administrator and they become autonomous and they're doing certain things that are not right, nobody challenges them. So it can't leave your family in dire situations when they can't challenge the administrator and you didn't leave clear instructions on what should happen to your estate.
Wow. If you just tuned in, this is Tomorrow Today webinar series powered by Enterprise Trustees. And today we're discussing planning, having a succession plan so that we don't leave all the chaos. If you just tuned in, we are live on Facebook. So go on to Facebook, Enterprise Trustees. We're also live on YouTube, and share as many times as possible. I always say that that's because this education needs to go for everybody, so that if you're part of a family, you do not become part of a chaos. You know, so let your uncle know that writing a will is important. Let your family members also understand that having a succession plan is also important. Now let me come to you, because, you know, the money is where the problem begins. When planning or having, you know, as part of our financial well-being, how can writing a will, nominating beneficiaries contribute to the overall financial planning or management?
Right. Cassandra, so you know, when it comes to financial planning and management, it doesn't end with us. It doesn't end when you invest, you want to have this kind of retirement, this kind of lifestyle at certain ages and all that. And like we've said earlier, life is full of uncertainties. But what is certain is that we will die. Unfortunately, we don't know when we die.
We don't want to talk about it.
So as part of the 360 management process, financial planning process, it is good that we nominate beneficiaries. Let me take you to the good book.
Okay.
Bible says, I think in Proverbs 13:22, say that a good man leaves inheritance for his children's children. So not only your children, but your children's children. So it's part of the financial planning process. So as part of your planning and the management, you are supposed to leave some inheritance to your children's children.
Absolutely.
You get it. So nominating beneficiary, we should see it as a very crucial part when it comes to financial management and planning. Because today when you're budgeting, I know that usually we'll put miscellaneous. And sometimes, if you're not careful, your miscellaneous will even be more than the other components. So as part of our financial planning, so let's see the nomination of beneficiaries and getting a will as part of the miscellaneous. In the unlikely event or the certain event that we pass, when we don't know when we pass, that means that we have some documents in place. We have elected or selected, chosen some people who are going to manage the funds that we left to continue the legacy that we want them to continue. So as part of the financial planning and management process, nominating the beneficiary, getting a will should be a key component.
It's key because it ensures the continuation of your generation.
Exactly.
If you're someone who is looking to, build legacy and leave legacy for generations to come after you. Cynthia, I'm sure you have some testimonies to share with us. I love stories of, the stories are the ones that we remember. And I believe that we can end this webinar series and someone might forget everything we say, but they will remember that story, and that will be the reason why they will go tomorrow and make proper changes to their financial, products that they have in terms of beneficiary, in terms of understanding who they want to leave things with. What are some of the stories that have come to you that you thought, if only things, had been done this way, would have avoided everything?
I mean, the stories are many, but this one will speak to how you shouldn't leave the will too late. Not too long ago, I had a call from a friend that the father was unwell, critically unwell. And at that point, he wanted to make a will.
Make a will.
Yes. So I'm sure we'll come to that, how you can make the will. Okay. But there are strict rules on the form of the will. Okay. So because he was unwell, we had to go to the hospital to take his instructions on what he wanted us to put in the will. Okay. So the idea was we'll go back, draft the will, come back and conclude the form of the will. He died the next day. Yes, he died. So he died without a will, because he left it too late, you see. So sometimes when you think that, okay, I'll have more time, you don't know what would happen to you,
absolutely,
because you really don't control your life. You don't know what happened to you. He just passed without leaving the will because he left it too late. Okay. So that's one story for making the will now. If everything that we've heard here today doesn't ginger you to go and make the will, because at that point in life, you actually start thinking about it. Oh my God, I'm going to die.
Yeah,
who will
take care of this? Yes.
Then at that point, you start panicking. You want to do it, but then it was too late. So the estate still went into intestacy. And then there are as for the court cases, there are many and varied, many and varied. That fights beginning from who was chosen as administrator of your estate when you died, especially where there are multiple women. Because what happens is every child or part of your family should be represented. So if you had 4 wives, 4 children with 4 different wives, each of these persons must be represented in your as administrator of your estate, because we must protect each person's rights.
Yeah.
So then it becomes who is going to be the administrator, and they never agree. Because what happens is, if maybe even getting your funds out of your bank, your administrators must sign the document.
Yeah.
And sometimes you can never agree to collate and get those signatures. It can be a problem, So if you had a will, you would have named executors of your will. Those are the only persons who would sign those documents.
Yes.
So if you leave it to administrative processes, there's always some sort of litigation on the matters if the families don't agree, especially if you had a large family and people feel like they are entitled to certain things in your estate. So as for the court cases, they are many and varied. Fights over properties that could last 30 years. When I was in active litigation, there was a case that was 30 years old.
Wow.
The man is dead and rotten and whatever, and people are still fighting about his
30 years.
30 years.
And some would even die. Those who are fighting, some would die.
Some would even die.
Their children will continue.
And they are still fighting
That's
about
a very
the
long
estate.
one.
Yes.
Now, when we talk about law, about the will, some of us are only thinking about the assets. Now that you're talking, I'm thinking about the responsibilities, the roles, like who's supposed to take care of kids and stuff like that.
Yes.
Are those also, stated in the will?
Yes, definitely. So the will, if you're making a will, you have to name an executor. So somebody who would look at the will and say, okay, he wanted this property to go to this person, this should go to that person, and would sign the legal documents to ensure that everybody gets what they are entitled to. So those persons are called the executors of the will. Where you have a trust within the will, like I mentioned, to take care of your young children, you can name a trustee of your will. So that person will be responsible for creating the trust. Usually we advise that you take the trust to a bank. So they would open a trust account with a bank, put those assets in it, but then the trustee would be the person you name, and then the beneficiaries of that. So they would manage the trust up until the kids are of an age that you mentioned. So those are the executors of your will, executors and trustees of your will. Then we have the people who benefit from the will. So those are beneficiaries under your will. And then we have witnesses. So how you're supposed to make a will, it must be in writing. It doesn't have to be a typed out document, but it should be in some form of writing. And it must be signed by you. The person making the will is who we call the testator. It must be signed by you, and then 2 or more witnesses. So we call that an attestation. 2 or more witnesses must attest to it. They must sign with you and in each other's presence. So that's just showing that they saw you sign this will, and they saw each other witness it.
Is that not the point where you get to know what you're getting?
No. So the witnesses don't need to know the contents of the will. They're just attesting to your signature. So you can tell them, this is my will. Please attest to it for me. They don't need to see the And beneficiaries of a will cannot witness it anyway. So if you name somebody as a beneficiary in your will, they cannot be witnesses to the will. So
let's just say, for example, someone is witnessing and they know what someone is getting. They end up eliminating the person so that they can be chaotic. So it's good that people don't get to know what
beneficiary. If you're a beneficiary under the will, you can be an attesting witness to the will. You can maybe be an extra witness, but not like one of the main attesting witnesses. So beneficiaries of the will are usually not witnesses.
Let me go to Nana, and I'll come back to you as to whether someone who is sick, how do you ascertain the state of mind of a sick person in writing a will? And now let me come to you. In terms of mistakes, what are some of the common mistakes that we make? Because you sit in the engine room with people who come and buy financial products, and they're making lots of mistakes, and that's what we want to avoid from today. What are some of the common mistakes that people make, and how can we avoid those mistakes?
I think the most common one I can think of is the name bit. So usually we expect, or we want you to indicate the legal name of the person you are nominating as beneficiary. There are instances where people will write names later on when the beneficiaries come. They present ID cards, and the names do not tally. Then it's like, oh, the name you wrote there, Amy Fieding. We can't verify me Fieding. So it's very important that whatever name you are indicating for the person should be the legal name. The name on the person's ID card or birth set, so that we'll be able to verify the beneficiaries when the time is due. Again, we see those who nominate several beneficiaries. We usually the allocation will be exceeding 100%. If it's exceeding 100%, in that case, we don't know whose allocation to reduce. In that case, I'll just send an email to Cynthia, and Cynthia will advise that let them go to court, get a letter of administration, because we can't work with it. You've given them more than the allocation. So how are we going to divide the funds or the benefits to them? So we have to take particular attention on the name that we indicate. And the allocation that we give to them. There is the other bit of the other details, like their phone number, their date of birth. There are instances where people miss the date of birth, but that can be pardoned to some extent, because when we get the ID cards, we'll be able to verify. If you have the correct name, we'll be able to verify the date of birth, and probably if there are any changes, our legal team will advise us on what to do. But the name is very important, and the allocation, how much you're allocating for them. And on the form, usually when you do the hard copy form, when you come to enterprise trustees, we expect you to sign If you can't sign, the thumb printing is there to ensure that, as earlier mentioned, it's a legal process. So we want to know that you are the person who actually nominated these people. So you need to assign, and the date should also be there. There are instances where people change beneficiaries so many times. Like I indicated, you're allowed to do that. So tomorrow when you are not there, what we'll do is that we fall on the latest update that you did. So it's always important that you do indicate the date when you're using the hard copy form. For the online portal for our stable, there's a timestamp there. So technical team will be able to pull and know that this update was done at this particular time and this is the latest, so that we'll fall on it. But those who use the hard copy form should ensure that it's dated and it's signed. So your name, the name of the beneficiaries, and their location is very necessary and important.
What is the process of nominating a beneficiary? I'm sure, all throughout the conversation, you've answered, a lot of that, where I was saying that, do you advise if the person should give more to wife and kids and less to, I'm sure we've touched on it. But in wrapping up, what is the process that people should keep in mind when nominating a beneficiary?
I think it's very simple. It's not like, well, the will where you have to get a legal representative. For the nomination of the beneficiaries on all your pensions accounts, you can walk into any of our market offices. Okay. You request for a form to complete, and you just indicate the beneficiaries. You can as well sit in the comfort of your home or office. Just go to our stable, the members portal. You log in with your credentials, go to your personal information, just scroll down to beneficiaries, and you update it there. So it's very simple. You don't have to go through a whole lot of process to do that. So
I'll come back to you so that you will answer the question of, if they do not find the beneficiary, what happens? Cynthia, let me come to you. Now, we've all understood that it's very, very important, crucial. Actually, as we're wrapping up here, we're all going to be thinking of where we're rushing to go and make sure that our will is in place, because now we know that it is very, very important. What is the process in making a will? Because I think one of the reasons why some of us have not done it is we're thinking, it's cumbersome, and I need a lawyer, and perhaps I have to pay Cynthia a lot of money. Oh, let me leave it. So what is the process of writing a will?
Yes, a lot of people are hesitant to do it because of the involvement of lawyers and costs. And costs. But as I mentioned, it's not, you don't necessarily need a lawyer for it. So long as you understand the requirements of it. Because it's governed by law. For the form of it, you need to make sure that at least it complies with what the law says. It should be in writing. You should sign it in the presence of two witnesses, two or more witnesses. So basically, that's a form of it. Those are the things you should remember. And also remember that if once it's signed, you can't put anything beneath the signatures. Because those will not be given effect to. It gives the idea that somebody else made the insertions. So it should be in writing, sign it, 2+ witnesses in the presence. That's basically the form.
That's a will.
Whatever language, the Act doesn't prescribe any particular language that you should use for making a will. So the lawyers will give you, I bequeath, I devise, we'll add that flair to it.
You can just write your simple,
you can say that I want my son to take this to my house.
Okay.
Yes. You can do that.
You can do that.
If you want to avoid the court, the lawyer part of it. So don't be daunted by the whole lawyer process and all that. You can take the Wills Act. The laws are available online. You can take the Wills Act, look at the formalities for a will, and follow that. Whatever you do, just leave one.
Yes.
Okay. What we advise is once if you've done this yourself, seal it. You can just seal the envelope. But we also advise that you use maybe candle wax to seal it. So that if it's broken into, we'll see.
Yes.
So you seal it and then keep it somewhere safe with your official papers. We advise that you tell somebody close to you
that you have
I have a will. You don't have to disclose the contents, but let them know that I have prepared a will. So it's among my documents. So that when you pass, they will know to look for it. For when you do the whole lawyer process. Once the will is done by the lawyers, we usually deposit it in the High Courts. And the High Court has a depository where it keeps people's wills.
Okay.
So you get a receipt for it. You can give it to your executors or somebody else in your family. If you pass, they would reach out to the High Court registry and retrieve the will. I think that some banks also have a repository where you can probably keep a will. I'm not sure, I don't know how popular or if it's a service they offer in Ghana, but I know other jurisdictions you can't even keep a copy of your will in a bank. Yeah, so those are really what to do. You don't need to get a lawyer, but just follow the formalities in the Wills Act. I think it's a 1971 Act. You can find it online. Follow the formalities, put it in writing, sign it, get 2 or more witnesses, and then you're good to go.
Cynthia, in your opinion, should we write our wills and keep it, under our beds or in our drawers and tell someone that I have a will somewhere? In your opinion, or could we actually maybe do it ourselves and bring it to the court?
Yes.
Is it possible?
It is
okay.
possible. As a lawyer, I would advise that you have it deposited.
Yes.
You can't really control what could happen in your space. It could happen that the person would have forgotten that you said it, that you left a will. But an executor, if you tell them, an executor of my will will hardly ever forget that situation, So we advise that if you can, get a lawyer. It may not be as expensive as you think. A lot of people think that, lawyers are so expensive, but it may not really be. And I know that, at least I have faith in my colleague lawyers. A lot of them offer pro bono services to maybe their churches, their, social groups, and things like that. So approach a lawyer, speak with them. You'll probably get a discount.
Now, for all the benefits that you get, when you have a will, we shouldn't be thinking about how much it will cost, to be honest. And from the way you've just explained it, it'll be better for you to go through a lawyer, have it, in a safe place, rather than you write, then the next thing, maybe your signature was not, then it becomes a whole, this is father's signature. No, that is not father's signature. Oh, no, I think someone has forged it. No, I don't think so. So I think to avoid all that, it will be better if you have a Cynthia sitting there. At least, then the legal thing is done and it is secured, just to protect your own finances and the people you love. Because I believe the whole sweat is so that we can keep our kids safe, we can keep our loved ones safe. So the most important thing is to do the right thing, to keep them safe when we are no more. In wrapping up, what are your final words, Nana?
Right,
what should
Cassandra.
people remember again, just before we go?
Okay, so as part of our financial management, financial planning, the financial security that we seek for everyone, I think we have to be intentional when it comes to nominating beneficiaries on our accounts.
Intentional.
It won't take you more than 10 minutes to do that, and you can do that at any point in time. Don't wait for your family to go through a whole lot of stress when tomorrow you are no longer there and they have to call transitions to come for your body, which will be called units by then, and they have to go through a whole lot of process to get the little fund that you left for them to probably have some peace of mind knowing that they have something to fall on to give you a befitting farewell. So it's very important that at every point in our life, and the Lord gives us room to do that once every 5 years, but 5 years is too much if you ask me.
If you don't find the person, what happens?
If you don't find the person, so over the period, we've had instances where employer, because the tier 2, tier 3 is usually from the employer side, they will advise that this person in our employment is deceased.
Okay.
And so we advise that if there are beneficiaries or family members who have contacted the employer, definitely the employer will know, so they should refer them to us so that we will take them through the process. Unfortunately, if you've not nominated beneficiary, then we'll have to let them get the letter of administration so that we'll disburse these funds for them. If you've nominated beneficiaries to, there are instances where people are doing personal pensions, and so it's not through any employer, and then they have not informed anyone, any family member, that I have this investment with Enterprise Trustees, I have this policy with Enterprise Life or and so when I'm no longer, you can fall on. Like Cynthia said, it is okay for you to at least inform someone that I have this investment somewhere.
Should
so
something happen,
someone should just follow up. When
Absolutely.
you come to enterprise trustees, we'll tell you, well, if you give us your name, your ID card, we verify, we check, no, you're not on the beneficiary list. These persons are on the beneficiary list, so get those people to come.
Get those people.
Yes.
All right.
Otherwise, when you go through the thorough process and you indicate their phone numbers, and today NPR is saying we should add the digital addresses to them. So if you go through that process and indicate their phone numbers or email address, digital address, and we get the notification from the employer or any family member comes to let us know that this person is deceased, we will go ahead and contact the beneficiaries to take them through the process, and it's very seamless. Once you do that, it's very seamless.
It's very seamless.
It's very seamless.
Very
so I'll admonish all of us to take some time after this session, just log on to our stable, log into your account with your credentials, go to personal information, scroll down to beneficiaries, and just update. You can do that once a week, once a month, once a year, if you so will.
Just like your friend.
Just like my friend.
Fight with the sister changes.
Yes.
Cynthia, in wrapping up, you know, before you give us your final words, if a person is sick, just like your friend, who determines whether he's in a good state at the time to do it?
Well, so, you know, when we talk about sound mind, right, you just need to ask if the person has the intention of making a will. So he's aware that, okay, I want to make a will. And he knows he's lucid enough to give you his assets. If the person is not able to give you the assets that he has, you know that at that point, he's not really of sound mind. So there are some questions, basic questions you can ask. Are you this property? If you mention the property, ask him to give you some sort of description of the property and his children. If he says, I want to give it to this child, which child is this? Just ask them some questions. If at the point you realize that the person is not, as a lawyer, advice that you don't proceed with it, because you know that the will can be contested based on its substance as well. If it's found that the person was not of a sound mind at the time, it means he didn't have capacity to make it.
Are there times when the person is induced or something?
Yes, so you know, if the person's of sound mind, it's not just about his maybe some sort of mental capacity. We talk about issues of duress, threats, you know. So if the person made a will under those circumstances, we call them vitiating factors. So or he made it under it's proven that, okay, somebody put a gun to your head and say, no, write a will and give me this asset. Or somebody threatened him, if you don't give me this asset, you will see, you know, something like that. So those are all vitiating factors that go to sound mind. So if those factors are found out, the will could be thrown out.
All right. In wrapping up, your final words. What should we remember you for?
I mean, the time to make a will is now, today, not tomorrow, because, well, tomorrow may never come. So I would really want, if you don't remember anything at all, the time is now. Is now. Right this minute. Okay. Also remember that you can update it. So I think a lot of people think that, oh, my assets are small, my estate is small, I just have one car, one house. Even so that. It's too small. I mean, that's an asset. You worked hard for it. So the time is really now.
Absolutely. The time is now. Cynthia Piedu is the Senior Legal and Governance Manager at Enterprise Group. And Nana Asante Amuako is the Head Customer Experience at Enterprise Trustees. It's been awesome having you two. Thank you so very much for coming. But just like Nana said, log on to the portal, right? And scroll down to beneficiaries, right? You log on with your credentials. With your credentials. Personal info. Okay. Scroll down to beneficiaries. To beneficiaries, and make sure that you update. Now, it doesn't only apply to your products with Enterprise, but it applies to any other financial product that you have. Make sure that you nominate a beneficiary. I hope today's series has been very, very beneficial to you. It has been for me, because I'm probably thinking, no, it's just the one this thing and one that. Still, make sure that you have a will. Why? Because none of us know when we are leaving this earth. This has been Tomorrow Today webinar series, powered and brought to you by Enterprise Trustees, Your Advantage. All you need to do is to dial *714*333#, and someone will most definitely get hold of you. My name is Cassandra. I'm a financial advisor. I'm a communicator, and I have been the one moderating for today. Awesome will come your way next time. Bye-bye.
Hi there, my name is Doreen, and welcome to today's edition of Retirement in 60 Seconds. Today, we'll be talking about the importance of updating your beneficiary information on your pension account. As a member of a pension scheme, you are required to nominate beneficiaries for your account. This will ensure that in the unfortunate event that you are no more, your surviving beneficiaries, such as children, spouse, or other family members, will have a seamless and smooth experience accessing your accrued benefits in your pension account. Secure the future of your loved ones. To update your beneficiary details, go to our member online portal, The Stable. Log in with your credentials, select personal information, scroll down to beneficiary details, and select Add Beneficiary. Make sure your beneficiary information is up to